Welcome to the latest episode of International Law Chats, or ILC for short, the podcast from the American branch of the International Law Association. The podcast airs on the first Monday of every month, and we hope that you can join us each month for a new episode. I'm Chiara Giorgetti, Professor of International Law at Richmond Law School and a non-resident faculty at the Vienna Diplomatic Academy.
And I'm Milena Sterio, a Professor of International Law at Cleveland State University College of Law, and also Managing Director at the Public International Law and Policy Group. Today, we're excited to be chatting with Dr. Beth Van Schaack. Beth is joining us from the European University Institute in Florence, where she's visiting fellow. She's also a distinguished fellow at the Center for Human Rights and International Justice at Stanford University and the founder and principal of the Alliance for Diplomacy and Justice. Beth served as the Biden administration's U.S. Ambassador at Large for Global Criminal Justice at the U.S. State Department from 2022 to 2025. She had also served as deputy in the same office from 2012 to 2013. Prior to returning to public service, she was the Leah Kaplan Visiting Professor in Human Rights at Stanford Law School, where she taught international criminal law, human rights, human trafficking, and a policy lab on legal and policy tools for preventing atrocities. Previously, Beth was on the faculty of Santa Clara University School of Law and a practicing attorney with Morrison & Forster LLP. She was also law clerk with the Office of the Prosecutor of the International Criminal Tribunals for the former Yugoslavia and Rwanda. Beth is a graduate of Stanford University, Yale Law School, and Leiden University. Welcome, Beth.
Thank you. It's great to be here.
Now, could we start with your position as Ambassador at Large for war crimes issues? Can you tell us more about your mandate and how you approached the role, how you decided to advance it? What were your priorities, and what did your day-to-day look like while you were at the State Department?
Yeah, great. So the Office of Global Criminal Justice was the brainchild of Madeleine Albright when she was Secretary of State. And her theory was that she wanted an office that would report directly to her, but that would be a liaison with the ad hoc criminal tribunals, which had just been stood up by the Security Council. Over the years, the mandate of the office has expanded to include the whole range of transitional justice mechanisms that can be deployed by states that are emerging from periods of repression or armed conflict. And so our job was essentially to advise the Secretary, to advise other elements of the U.S. government, to advise partners and allies, and to work with civil society actors around the world in order to try and advance justice wherever atrocities were either being threatened or were underway or had happened, and there was a justice response that was being considered. Over the years, we eventually got some programming money, so we were able to do foreign assistance in this space and generally would fund non-governmental organizations that were supporting tribunals. We could also fund the tribunals directly, and so would fund some of the international investigative mechanisms for Myanmar, for example, or for Syria. My remit was global, and I had a pretty small team. We were about 30 subject matter experts and programming specialists. So we really did have to think about where we could prioritize our efforts. And we came up internally with a sort of algorithm in this regard. So the most important question was, is there space for prevention, for mitigation, or for response? Are atrocities underway? Are they threatened, or have they happened? Is there a justice process that's being contemplated, whether internal to the country, or is there a tribunal or an investigative mechanism that was created in the multilateral space that we could support and work with? And did I have funding, dedicated funding from Congress? Because they would most sometimes earmark funding for particular situation countries. But then there were some more difficult questions. So, for example, is this a situation where U.S. bilateral relationship is really governed by a single metric, like a counterterrorism approach? So there really wasn't room for me to work on justice issues because the situation was overtaken by that particular equity. Or did I have an ambassador or a local country team that was supportive of this work, or were they potentially a little bit hostile to the idea of justice? And so it would make it more difficult for me to work in a particular country. So given those priorities, we tried to work in areas where we could actually make a difference with either our programming work, our policy work, our diplomatic efforts, and where we can support a genuine, inclusive, victim-centered justice process.
Thank you, Beth. This is very, very interesting. Let me ask you more of a specific question and focus on one part specific of your portfolio to which I know you dedicated a lot of time and in fact, in the context of which we met also, that of Ukraine. Now, Russia's invasions of Ukraine has triggered really an unusually robust and coordinated response by the international community, especially in Europe, we are now based. You have multiple investigations, innovative use of domestic jurisdiction, sanctions regimes, proposal for special tribunals, for example, ad hoc on aggression, which is now being developed by the Council of Europe, and of course also the creation of the Register of Damages and the forthcoming Claims Commission. Now, some describe this as a potential turning point for international criminal justice. Do you see the Ukraine contest as somehow transformative? Which legal or institutional innovations emerging from this specific moment, if any, do you believe could reshape accountability mechanism, maybe beyond Ukraine, and teach us something in the larger context? And conversely, do you think there are maybe risks that arise from maybe the specific geopolitical fragmentation we're witnessing in this context?
Yeah, so I think the coordinated response to Russia's brutal war of aggression in Ukraine really gives us a heartening example of what can be accomplished, the kinds of creativity that can be tapped into when a big chunk of the international community is really dedicated to the imperative of justice. So, as you've said, there's been so many fascinating innovations and expansions around international justice that have been occasioned by the situation in Ukraine. So you've touched on some of them, but, re-enlivening the principle of individual criminal responsibility for the crime of aggression and the establishment of a regional aggression tribunal. I was very proud to announce the United States' support for that effort. It was not a foregone conclusion, given our own forays into Iraq and other places. Efforts within the Council of Europe really show what can be done at a regional level in terms of creating hybrid institutions. So the special tribunal, but also the work that you've done with the Register of Damage, and then now the new Claims Commission that's being created. We've seen this in Africa, for example, with the Special Criminal Court in the Central African Republic, and with the Habre Tribunal, which had the support of the African Union. But also now we're seeing in the Gambia the creation of a hybrid tribunal with support from ECOWAS. So bringing things down to the most local level possible while still adding that international expertise, support, funding, and the legitimacy that comes with having external actors involved in a justice process. The Register of Damage and the Claims Commission, I think, really emphasize the importance of reparations, that survivors see this as critical to their rehabilitation after experiencing atrocities. And so the fact that you all are coming up with a really evidence-driven way to evaluate claims, and then ultimately it is hoped to pay some of those claims out. Obviously, we need to resolve the question of the liquidability of whether or not Russian assets can be liquidated and put to this purpose. But having that system in place, I think, is going to be a really important precedent for other situations. The further expression of universal jurisdiction around the world, so not just in Western European states, but we're seeing states in the region like Poland exploring their extraterritorial jurisdiction possibilities, and even Argentina looking at the situation in Ukraine, showing that states around the world can step up and help to be part of a larger ecosystem of justice. I think that's an important development that the situation in Ukraine has really inspired. So there's tons of energy here. Now, the question, of course, is how do we deploy all these new ideas in other circumstances where you maybe don't have the full support of the international community, of a big chunk of the international community? And so building the political will to focus on other parts of the world that are also experiencing atrocities is really important. But we now have these precedents. We have these models that can be adapted and borrowed in ways that can advance justice in these other situations. Ultimately, I was really pleased to see that the U.S. being very supportive of these efforts under the Biden-Harris administration. I mean, I felt like I had a wind at my back whenever it came to Ukraine. It was sometimes harder to push these issues in other circumstances. And this gets to the final part of your question, which is the sort of fragmentation and selectivity of international justice. But I'm generally of the mind that we should push it and support it wherever we can, because once those precedents are created, they exist forever, and then they can be deployed in other circumstances when we can build the political will to do so.
Beth, I would like to follow up on another issue that was and is at the top of your agenda, which is crimes against humanity. As you know, there's now a momentum towards a dedicated Crimes Against Humanity Convention at the United Nations, building on the International Law Commission's draft article. The first PrepCop meeting just took place recently at the United Nations. Some of us were there in attendance, and further negotiations are scheduled. From your perspective, what concrete gap would such a treaty fill in the current accountability architecture, and do you actually see an appetite for its adoption in the current geopolitical climate?
This is an incredibly important initiative, and huge kudos to Professor Milena Sterio for really launching this project and moving it from an academic exercise into now the multilateral realm. It's being considered now by the General Assembly's Legal Committee. Incredibly important. Crimes against humanity were a critical innovation in the Nuremberg era. The charge allowed the tribunal, the prosecutors, to charge individuals for harm that was committed to their compatriots. At the time, the existing international law really didn't contemplate that. War crimes were crimes that were committed against either the civilians or the prisoners of war or combatants of an adversary. And so the huge innovation really laid the groundwork, I think, for much of the edifice of international human rights. For various reasons, that crime was not codified after World War II in a way that other international crimes were, like war crimes in the Geneva Conventions. The crime of genocide, the brainchild of Raphael Lemkin, really trying to put a name to this effort to destroy a group in whole or in part. Even torture, terrorism, all of these other crimes have become subject of dedicated treaties, but crimes against humanity never was. And so that's the gap. And the result is that many states have not incorporated the prohibition of crimes against humanity into their domestic penal code. The United States, for example, has no crimes against humanity statute. It's been a real gap. It's meant that the United States can be a safe haven for individuals who commit crimes against humanity. And we've seen some circumstances in which charges have not been able to be brought because they don't rise to the level of genocide. They can't be charged as war crimes. And so individuals have to be dealt with through immigration remedies or other forms of redress. So getting that international shared definition is going to be incredibly important. But what the treaty also offers is a whole regime of mutual legal assistance. So other states' parties can assist each other with prosecutions, with extraditions, with the sharing of evidence. They'll now have a platform to do that through the Crimes Against Humanity Treaty. They also have the Hague-Ljubljana Treaty as well, which is very much geared toward that same goal. But having these working in tandem, I think, will be really important. It also obligates states to incorporate crimes against humanity into their domestic codes and then to utilize principles of extraterritorial jurisdiction so that they can do these cases domestically in a decentralized fashion, so that if a perpetrator lands in their jurisdictional reach or if survivors and evidence are present, it'll enable them to open a case themselves and we don't have to create a dedicated tribunal or try and get jurisdiction before the ICC. So democratizing justice, I think, is really important. And the more we can do that, the better. In addition, I think thinking about just support for the concept of crimes against humanity and showing that it is an established crime under international law will just help give more courage, I think, to the world's prosecutors that may have a crimes against humanity statute on their books, but they've never used it before. And so having this kind of political support behind the definition and a dedicated definition that we can all point to, I think will really help encourage some of these cases to be brought. So it's a really important effort. I was very happy that the Biden-Harris administration was supportive of this effort. It's really hard for us to ratify treaties, as many of the listeners will know. I mean, we are the only state that has not ratified the Convention on the Rights of the Child, the Law of the Sea Treaty, which has huge national security benefits for the United States. We espouse those rules as a function of customary international law, but we've never ratified the treaty. It's just hard for us to do that under our system, but I was really glad that we were supportive of that effort and supportive of moving it forward in the UN system so that it can now be the subject of real interstate negotiations and eventually create a final treaty that can be open for ratification by other states. And, maybe someday we'll join the treaty in the way that it took us decades to join the Genocide Convention, but we did finally do so and incorporate the prohibition of genocide into our penal code.
Thank you very much, Beth. Let me follow up on something that you said, but also maybe Milena's points, and maybe move from specific questions to more general, the general perspective, and talk a little about the current geopolitical climate. somehow we seem to be living through a contradictory moment. So in practice, there is unprecedented documentation of atrocities, expanded investigative mechanism, and yet on the other side, deep political polarization that often stymies enforcement. And then more generally, at the same time, as we discussed, on one side, we see crisis at the International Criminal Court, but at the same time, also the creation of the ad hoc tribunal for aggression, and we have just discussed also the negotiation of the Crimes Against Humanity Treaty. Now, from your vantage point, is the International Justice Project facing a crisis of credibility, a phase of recalibration? Is it successful as it is? Or what is it? How do you see the moment? Do you think that expectations about accountability, and maybe particularly the speed, feasibility, and universality of justice, are representing political realities? How does accountability look like for you in this contemporary world?
Well, Chiara, you're absolutely right that the field is experiencing cross currents at present. We have some incredible developments happening while at the same time a retrenchment is underway, particularly coming from the United States government and their complete change of approach towards the International Criminal Court. The project of international criminal justice has always been about holding high-level individuals and all individuals responsible for their role in committing or enabling atrocity crimes. There's always going to be resistance to this project, even in the best of times. We're seeing more resistance now than we have in the past, but it's not a new state of affairs necessarily. And even within fully supportive states of the project of international justice, there are always going to be countervailing forces that are going to have to be dealt with by those who are sort of internal to that system, working within and without government to try and move things forward. While lots of these efforts are proceeding in a decentralized way, and we've talked about Ukraine in particular, I do think that the ICC is particularly vulnerable right now. Principals who are just international civil servants doing their jobs, trying to deliver justice for victims of atrocity crimes, have been subjected to sanctions by my own government that are crushing and unjustified. And the Assembly of States Parties is not really responding as robustly as one might have hoped, at least as far as we can see publicly. The court itself has a very mixed record, marked by really spotty state cooperation. So there have been some incredible developments. So the Darfur conviction, bringing Duterte into custody and having that case move forward, some incredible state cooperation and coordination around arrest operations. Powerful individuals who have been subjected to arrest warrants have had their movements constrained, even if they're not fully in custody. We have seen that empirically, that they're not able to operate freely within the international community. We've had groundbreaking arrest warrants against senior Taliban figures for gender persecution, including with respect to harm to individuals whose gender identity does not conform with the Taliban's very strict and retrograde expectations. But at the same time, we've had really salient examples of non-cooperation. So as you mentioned, I'm located here in Italy, and Italy recently released a Libyan who'd been subjected to a sealed arrest warrant for reasons that are quite flimsy and inexplicable in some respects. So it is obviously in violation of their Rome Statute obligations, but arguably also in violation of their UN Charter obligations, because the situation in Libya was referred to the court by the Security Council. Now, interestingly, I understand that there may be a criminal investigation underway here as to whether or not individuals involved in that decision could be charged with aiding and abetting the evasion of justice by virtue of allowing that person to return for reasons that appear to be based upon wanting Libya to continue to interdict migrants before they reach Italian shores. So for, unfortunate reasons. But at the same time, notwithstanding all of these issues from states and state cooperation in the ASP, the institution itself is also continuing to disappoint in some very important ways. We've had rulings like the one recently exonerating a member of essentially ISIL working in Mali for gender persecution. The ruling it's hard to follow. It's unsubstantiated. It's poorly reasoned. That's very frustrating, I think, for advocates of justice. We've seen the court continue to receive criticism for its unhealthy work environment. And then we have the chief prosecutor who stands accused of committing sexual assault. And even if this was a purely consensual relationship and the results of that investigation have, again, inexplicably not yet been released, it would be entirely inappropriate from the perspective of creating a hostile work environment with respect to other personnel, and yet he has refused to step down. So the field, since its renaissance in the 1990s, have experienced a number of expansions and contractions over the years. We're in a retrenchment period. And I think for those of us who believe in the goals of international criminal justice, the important thing to do now is to continue to push forward those efforts that are possible, that we have momentum and wind in our sails, and then try and protect and defend the prior developments and defend the institutions against these attacks, in the hope that we'll, move through this period and have another period in which there's a more coordinated commitment by the international community to support these efforts.
Thank you so much, Beth. Now, switching gears a little bit, I would like to ask you a question about your own career. In your career, you've moved between academia and senior government roles. How has working inside the government reshaped your understanding of how international criminal law actually functions in practice compared to how it is often conceptualized in scholarship?
So I think it's extremely valuable to work within governments. Ultimately, international law and international institutions are created by governments or with the assistance of governments. And so I think we all need to really understand how governments function. And we know, of course, that governments are not monolithic. They're made up of different organs, different elements, different agencies that all have their own equities that they're trying to advance. And so learning how to navigate those potentially competing equities is, I think, extremely important for those of us in the field. I have worked on this field, as you mentioned, for many, many decades from a number of different perspectives. I've been a practitioner, I've been an advocate, I've worked with big international multilateral organizations, I've worked in really, really tiny grassroots organizations, I've been an academic, and now I've had a couple of diplomatic roles. And I think each one of those roles is enhanced by the fact that I've had experience in the other roles. So I'm a better advocate having worked in government, I'm a better academic for having worked in government, and then I'm a better diplomat for having been an academic. I can bring some of the academic literature to bear in debates about how we should be responding to atrocities that are happening around the world. I can bring forth comparative models and historical examples. I can cite the academic empirical research that shows that the rule of law is better instantiated in transitional states when there is some kind of a justice response, very self-consciously by those particular societies. I can show how deterrence is built slowly by having measures of accountability and having that disseminate throughout a system so that perpetrators will think twice before they reach for atrocities as a tool to consolidate their power or to try and eliminate an adversary. And so bringing to bear the various perspectives that I have gathered, I think made me more effective within government. Ultimately, it's about finding your allies within the different agencies within a particular government, and then also understanding where you may experience some resistance because there's going to be a competing equity involved, and trying to figure out what's motivating that resistance, and is there some way that common ground could be reached? And I think having that kind of approach internally was really effective because people, I think, saw me as a straight shooter. They were someone that they could negotiate with. And ultimately, we would get to a point that all of the various agencies were generally okay with. It maybe wasn't exactly what I would have wanted, but it set a new precedent. And then, live to fight another day when the next situation emerges. But we were then on record as having done something unique and new that the U.S. government maybe had never done before. So I do think it's really important for those of us in the field to understand how government operates, and you'll just be more effective, even if you're not in government, if you know the kinds of constraints and bureaucratic maneuvering and just the slow process of policymaking. If you understand how all that works, you'll just be a better advocate for the principles of international justice going forward.
Right. Thank you very much. I do completely agree. I think especially for international lawyers, it's important to be both practitioners and academics, but at the same time. Let me ask you maybe a little bit of a personal question, if you don't mind. You have spent your career working on some of the gravest, really, crimes imaginable. On a personal level, what sustains your commitment to this work? Has your understanding of justice or even of hope evolved over time? And what advice would you give to younger people hoping to enter a similar career and follow your path?
Yeah, so I have been in this field a long time, and it does expose you to extremely difficult fact situations. I often don't ask survivors to describe their experience to me because I don't want to re-traumatize them. And that's not really my role. I would often ask them what their vision of justice is. And then I would work with them and their advocates to think about how we could build a system that would be responsive to those preferences and expectations. Nonetheless, they often want to tell their story. And so, over the years, I've just heard some horrific stories. But I draw a lot of energy from the courage of survivors and from their unquenchable quest for justice, the fact that they thirst for it and they look to us, those of us who are policymakers, academics, justice advocates, they look to us to help advance that vision. And so they're relying upon us. And so I often felt the responsibility of doing that given the unique position that I was in. But it also gives me great energy and inspiration to keep moving forward. I also think it's really important to understand how processes of vicarious harm work and recognize them in yourself, because you may think you're strong and you can, handle these situations, but you often won't understand how it's actually impacting you or your interpersonal relations. And so understanding vicarious trauma and having a way of dealing with it in terms of self-care. I'm a huge believer in having a physical practice. I think that's a great way to kind of get out of your head, get out of the issues, get into your body, and work through some of those issues. And I think also being really open about talking about it, I think is incredibly important. I tried to institute a trauma-informed approach within my team, and we created a kind of protocol that then was disseminated throughout the State Department for other offices that are dealing with traumatized individuals. And so we would share notes and perspectives with some of those other functional offices that are also dealing with survivors. So I think, having an opportunity to get out into the field was really important to me, because I always returned to Washington and the big bureaucratic fights with my batteries recharged, because I felt like I was channeling the expectations of those survivors and their faith that the international community would respond appropriately to the atrocities that they experienced.
So to wrap things up, thank you so much, Beth, for taking the time today to join us. And thank you for sharing your insights on these very important issues. I really enjoyed our conversation. And if our listeners have too, you can join us on the first Monday of every month for more international law chats. And as always, thank you to our amazing podcast producer, Freya Dowdy-Wagner. Thank you.